Good evening and welcome. It is time once again for CU Immigration here on WRFU LP Urbana, 104.5 FM and UPTV. I will be your host for this evening. My name is Mr. Garza, and I am here to let you know that WRFU is an open forum for the Urbana-Champaign community. Views expressed are those of the speakers and are not intended to represent WRFU or UCIMC or, as we like to say on the televised version of this show, UPTV, or YouTube for that matter, because we're also on YouTube. We're everywhere you want to be. So, once again, here I am. Various news and views about immigration. Here's something that I thought was kind of interesting. This was entitled, Immigration Judge Subject of Complaint by Lawyers Retires. And that's kind of a bad thing when lawyers are complaining about you all the time. Something is wrong with the way you are operating. Anyway, a San Francisco immigration court judge who was the subject of a complaint to the U.S. Justice Department involving hostile and biased treatment of immigrants abruptly quit his post this week. In a letter announcing his retirement, Judge Nicholas Ford did not acknowledge the complaint by local attorneys representing immigrants, the San Francisco Chronicle reported Friday. Instead, he criticized the entire court system and called its managers a fearful community whose primary interest has never been the growth of those they oversee, but rather their own continued employment. I am an older judge, and it is hard to understand how any court system can function like this, he added. Ford was a criminal court judge in Cook County, Illinois, before being named to the immigration court bench in 2019 by then acting Attorney General William Barr. Okay, that's a bad sign right there. During his tenure in Chicago, he was criticized for jailing a pregnant woman without bail for a nonviolent crime, and had a high number of rulings overturned by appellate courts, according to Injustice Watch, a justice watchdog group. Last November, let's try it with a full voice, a coalition led by the San Francisco Bay Area chapter of the National Lawyers Guild called for his removal from the bench, alleging in a complaint that Ford acted in an aggressive, unprofessional, and demeaning manner toward immigrants. The Guild said the Justice Department closed its investigation into Ford last month without disclosing whether any disciplinary action was taken. Ford and the Justice Department did not respond to requests for comment from the Chronicle. The Guild said in a statement Saturday that it believes the public pressure for Ford to be removed from the bench had an impact. Knowing no more about this than just what I'm reading here, there's some bad signs in here. And it sounds like a good thing that he's gone. Okay. And since I am always complaining about Republicans, as you may have noticed, or at least the Republican Party and its treatment of immigrants, I wanted to at least bring this article up. Entitled George W. Bush Calls for Bipartisan Immigration Action. Now, I don't necessarily agree with everything he's saying, but at least here's someone that represents what you might call an older school of republicanism that isn't so reflexively anti-everything. I shouldn't say anti-everything, but anti-anything that Democrats are for or anything that supports or promotes the welfare of people who aren't white, basically, has now become the Republican Party's just reason for existence. I was going to say raison d'être. I don't know if I'm pronouncing that correctly. Raison d'être? French? I mean, reason for being. Anyway, so I'm always kind of surprised and happy when a Republican turns out to not be in that group for some reason. So we'll read it and then we'll talk about it. Former Republican President George W. Bush is calling for bipartisan action on several immigration measures. calling for a restoration of the people's confidence in an immigration system that serves both our values and our interests. Good. In a Washington Post op-ed published on Friday, Bush strikes a gentler tone on immigration than the one often uttered at the highest levels of today's Republican Party, which has largely recast itself in the mold of Donald Trump, whose demonization of immigrants was a central part of his political strategy. As I was saying, the op-ed also comes at a time when the U.S. is seeing a surge of migrants coming to its southern border, and the Biden administration has struggled to handle the record influx. Quote, "The help and respect historically accorded to new arrivals is one reason so many people still aspire and wait to become Americans. So how is it that in a country more generous to new arrivals than any other, immigration policy is the source of so much rancor and ill will?" Bush wrote. The short answer is that the issue has been exploited in ways that do little credit to either party. And no proposal on immigration will have credibility without confidence that our laws are carried out consistently and in good faith. He's both siding it a bit more than he should, but hey, he kind of has to do that. Bush advocated for embracing the Deferred Action for Childhood Arrivals program and providing a pathway to citizenship for immigrants brought to the U.S. as children. He also proposed a secure and efficient border, adding that we should apply all the necessary resources, manpower, physical barriers, advanced technology, streamlined and efficient ports of entry, and a robust legal immigration system to assure it. While Bush recommended effective border management, the former president wrote, "We cannot rely on enforcement alone to prevent the untenable and so often heartbreaking scenes that come with large-scale migration." Anyway. Furthermore, Bush outlined the need for a modernized asylum system and suggested that Congress work to reshape the current asylum system to guard against unmerited entry and reserve that vital status for its intended recipients. Kind of heavy on the... While Bush stopped short of calling for citizenship for the millions of undocumented people currently living in the U.S., he said he supports increased legal immigration and suggested requirements for earned citizenship, including proof of work history, payment of a fine and back taxes, English proficiency and knowledge of U.S. history and civics, and a clean background check. Bush is set to release a collection of portraits of American immigrants he painted in a book titled Out of Many, One. He's doing a book tour. He wrote in his op-ed that the book is not meant to serve as a policy agenda. Bush, who lives in Texas, has for years highlighted the immigrant community in his home state and has often praised America's immigrant history while advocating for immigration policies. In his second term as president, Bush pushed an immigration bill that aimed to create a pathway to citizenship for some of the 12 million undocumented immigrants and sought to toughen border security, but the bill ultimately stalled in the Senate in 2007. Friday's op-ed comes at a time of heated debate over immigration in Washington. Progressives are pushing President Joe Biden to prioritize legislation that would offer a pathway to citizenship to undocumented essential workers in the second part of his two-part infrastructure package set to address education and childcare. He's also under pressure from the left to raise the cap on refugee admissions, which he has resisted out of concern about the political optics of such a move coming during the current border crisis. Can't read today. Meanwhile, Republicans, sensing a political opening, have depicted the situation at the border as a crisis that is overwhelming the Biden administration, which has made it difficult to pass legislation through a 50-50 Senate that can attract the Republican votes necessary to break a filibuster. Okay. Well, one thing right off the bat that I like about this article is that they note that it's the filibuster that causes the 60 vote threshold that we're often hearing about. Too many news sources write about that as if that is just an automatic feature of the Senate. It is not. The Senate is 51 and 50, or, it's whoever gets the most votes, period. It is the majority votes. But because of the filibuster and because of the way it is so often used just as a point of saying, I don't even want to deal with this thing, so we're just going to shut it down right now. That's where the 60 vote threshold comes from. And I'm glad that they wrote it this way. It takes a couple of more words, but at least it makes it clear what's going on. Secondly, Bush is a Republican, so naturally he's going to be heavy on border enforcement and all that kind of thing. But I do like that he pointed out, quote, so how is it that in a country more generous to new arrivals than any other, immigration policy is the source of so much rancor and ill will? The short answer is that the issue has been exploited in ways that do little credit. And I'm leaving out to either party because that's unnecessary, both sides ism, and it is unreasonable. There are some grandstanders on the Dem side, for sure. There are grandstanders everywhere in politics, but by and large, the issue has been exploited by Republicans. But anyway, at least he's talking about it. I get the sense, though, that this is just for his book and not really because it's that big a deal to him. But who knows? Maybe he cares. I mean, he was at least decent-ish on the topic for a Republican back in his day. Whether or not this will sway anybody, I don't think so. But, credit where credit is due. All right. Moving on. Here we have something entitled Immigration Dispute May Determine Whether Tens of Thousands of U.S. Residents Can Get Green Cards. Oh, this is about the Supreme Court here. Sanchez versus Mayorkas, scheduled for oral argument on Monday, focuses on whether non-citizens who have been granted humanitarian relief from deportation can seek lawful permanent residency in the United States through a process known as adjustment of status, without first leaving the country. Or must they depart the U.S. and complete their applications for permanent status while abroad? The statutory question presented is whether non-citizens certified by the government for the humanitarian relief program known as Temporary Protected Status, or TPS, have been admitted to the United States as requirement by the Adjustment of Status statute. Jose Sanchez and Sonia Gonzalez, a married couple from El Salvador who had lived in the United States for decades, argued that the specific provision regarding adjustment of status for those granted TPS demonstrates Congress's intent to treat them as admitted for this purpose. The government rejects that interpretation, insisting that the general adjustment of status requirements apply. This question has split the circuits and holds profound consequences for tens of thousands of people, those holding TPS, their families, neighbors, and employers. Under the TPS program, certain foreign nationals are permitted to remain in the United States if their country of citizenship is deemed to be in a crisis as a result of armed conflict or a natural disaster. 12 countries currently have that designation. The Biden administration has adopted the same approach as the Trump administration, advancing a statutory interpretation that would render almost all TPS holders ineligible to adjust their status to lawful permanent residence, colloquially known as green card holder. From an institutional perspective, the government's argument is somewhat counterintuitive. In a statute that undisputedly authorizes executive discretion to alleviate hardship in the immigration process, the government argues that it should not be allowed to exercise discretion at all to non-citizens present for humanitarian reasons. Access to the adjustment of status process in the U.S. is a lifeline for many non-citizens. Leaving the U.S. to accomplish a status change costs money, and because the immigration bureaucracy often moves slowly, can jeopardize employment and strain families. Moreover, the non-citizen's location outside the U.S. may limit their ability to challenge government action should an unforeseen legal issue arise. Most importantly, non-citizens may be barred from re-entry for up to 10 years. In 1996, 6 years after creating the TPS program, Congress passed a law penalizing non-citizens unlawfully present in the U.S. More than 180 days of unlawful presence leads to a 3-year ban on returning. More than 365 days of unlawful presence results in a 10-year bar. These bars take effect once the non-citizen leaves the country. As a consequence, a non-citizen seeking a green card, often based on marriage to a U.S. citizen, may not be permitted to rejoin her U.S. family for 10 years. Permission to adjust status within the U.S. avoids this result. Sanchez and Gonzalez came to the U.S. from El Salvador without authorization in the 1990s. They received protection after the U.S. designated El Salvador for TPS in 2001 in the wake of devastating earthquakes, and they have maintained TPS status for 20 years. In 2006, Sanchez's employer filed an immigration visa petition for Sanchez as a skilled worker. Immigration officials approved this petition as well as a derivative petition for Gonzalez. The government, however, denied the couple's later application to adjust to lawful permanent resident status. Immigration officials ruled that the original unauthorized entry disqualified them from consideration for a discretionary grant of adjustment of status. Accordingly, the only way for Sanchez and Gonzalez to obtain green cards would be to leave the U.S. and then apply to return. But they would be barred from re-entry for 10 years because they were in the U.S. without authorization for more than 365 days. Petitioners challenged the denial of their application for adjustment of status and won at the district court. On appeal, the U.S. Court of Appeals for Third Circuit reversed. This widened the circuit split. The Third Circuit joined the U.S. Court of Appeals for the Fifth and 11th Circuits, while the U.S. Courts of Appeals for the Sixth, Eighth, and Ninth Circuits took the contrary view. Boy, this is getting complicated. The government argues that Sanchez and Gonzalez are ineligible for the Immigration and Nationality Act's adjustment of status procedure, codified at 8 U.S.C. 1255. Sanchez and Gonzalez argued that the TPS statute, codified at 8 U.S.C. 1254, not 1255, affords the executive discretion to grant their applications for lawful permanent residency without leaving the country. The textual intricacies and dense cross-references in the statutes give the Supreme Court room to embrace either side's perspective. Humanitarian, family unity, and efficiency goals favor Sanchez and Gonzalez. Reinforcing the penalties for unlawful entry supports the government's interpretation. Wow. The Section 1255 adjustment of status process came into existence in 1952, long before the TPS program. It provides a mechanism for certain non-citizens living in the U.S. to change from temporary to permanent status without leaving the country. Congress made the adjustment of status process discretionary, but it occurs routinely. Roughly 50% of all non-citizens who qualify for green cards, more than 555,000 non-citizens each year from 2016 to 2019, take advantage of this procedure. After their employer sponsors them or their spouse or parent petitions on their behalf, they obtain their green cards while remaining on U.S. soil. Critically, for the purposes of this case, Section 1255A makes this in-country process available to non-citizens who were inspected and admitted or paroled into the United States, so long as 1. The non-citizen applies for the adjustment, 2. The non-citizen is eligible to receive an immigrant visa and is admissible as a permanent resident, and 3. An immigrant visa is immediately available. Subsequently, in 1990, Congress created the TPS program to furnish a framework for temporary humanitarian protection for individuals already in the U.S. whose home countries are in crisis. The Secretary of Homeland Security has the discretion to designate countries experiencing humanitarian crises, including natural disasters and civil war. Nationals of the designated countries, if present in the U.S., receive TPS, which authorizes them to seek employment and prevent deportation during the crisis. Section 1254A, F4. That's right, 1254A, parentheses F, parentheses 4. This is so you can look this up yourself. States that they are not lawful permanent residents of the U.S., but specifies that for purposes of adjustment of status under Section 1255, the TPS holder shall be considered as being in and maintaining lawful status as a non-immigrant. That sounds pretty cut and dry. However, significantly, nationals of designated countries can obtain TPS even if they are not in lawful status. Here's where we butt heads. Thus, TPS is available to individuals who entered the United States without inspection and admission, which is what some people call illegal immigration, but that's the official term for it, and those who entered lawfully but overstayed or did not maintain lawful status. In fact, the overwhelming majority of people who are granted TPS by the government entered without inspection. This raises the stakes of the statutory issue. When Congress mandated that a TPS holder shall be considered as being in lawful status as a non-immigrant, did Congress mean that all TPS holders should be treated as having been inspected and admitted or paroled as non-immigrants under Section 1255 for adjustment of status? Probably they didn't think about it. But anyway, the parties agree that Sanchez and Gonzalez were not inspected and admitted or paroled when they first entered the U.S. They agree that since 2001, Sanchez and Gonzalez have been granted renewed and maintained lawful status pursuant to TPS. They disagree about almost everything else. The textual meaning, the statutory structure, the underlying policy goals, the pragmatic consequences of the court's eventual decision, and the relevance of the doctrine of judicial deference to agency interpretation set forth in Chevron USA versus Natural Resources Defense Council, Inc., Incorporated. If you're still with me, thank you. Turning first to the text, both parties contend that the statute is clear, but focus on different statutory provisions and draw opposite conclusions. The government looks to the General Adjustment of Status Statute, Section 1255, which limits eligibility to non-citizens who were inspected and admitted. The statute, in turn, defines admitted as lawful entry after inspection and authorization by an immigration officer. Seems reasonable. In contrast, Sanchez and Gonzalez argue that the TPS statute's specific provision in Section 1254A, sub F, sub 4, controls for purposes of adjustment of status under Section 1255 and change of status under Section 1258, the TPS holder shall be considered as being in and maintaining lawful status as a non-immigrant. They assert that the phrase considered as being in makes the grant of TPS status the equivalent of being inspected and admitted as a lawful non-immigrant. They reason that when Congress directed that TPS holders shall be considered for adjustment of status purposes as being in lawful non-immigrant status, Congress intended that TPS holders be treated for adjustment of status purposes as if they had been inspected and admitted. Sanchez and Gonzalez bolster this argument by describing that detailed vetting that accompanies applicants for TPS as equivalent to the vetting that accompanies admission at a port of entry. They further argue that their interpretation avoids surplusage in the key statutory language. Maintaining lawful status requires TPS holders to ensure that TPS protection does not lapse, whereas Congress must have meant being in lawful status as a non-immigrant to signify something other than ensuring that the non-citizen has not allowed TPS protection to lapse. Good grief. The government responds that the concept of lawful status is separate from the concept of admitted, and Section 1254 AF4's omission of an express waiver of the admitted requirement for TPS holders revealed Congress's intent that only those who were inspected and admitted or paroled before they received TPS are eligible to adjust their status in the U.S. The government bolsters its argument by looking to other statutory provisions. For example, in authorizing non-citizens who served in the U.S. military to adjust status without leaving the country, Congress specified that the individual shall be deemed for adjustment of status purposes to have been paroled into the U.S. Similar legislation applies to certain non-citizen juveniles. The government concludes that the absence of similar text in the TPS statute indicates a congressional choice to leave the admitted or paroled requirement in place when TPS holders seek to adjust their status. Okay. Sanchez and Gonzalez, too, look to other portions of the Immigration Code for support. Well, of course. They point out that Congress uses admitted or admission in multiple statutory provisions that clearly do not refer to inspection by an immigration officer at the initial entry into the U.S. They note that the special legislation adopting the deemed to have been paroled text. Okay. Sorry, I was going to, that it reads in a strange way. They note that the special legislation adopting the deemed to have been paroled text all post-dates the TPS statute, and they reinforce their textual argument by looking to 8 U.S.C. 1258, which offers a change of status procedure analogous to adjustment of status. The text of Section 1254 AF4 tracks both requirements set forth by Section 1258. And Sanchez and Gonzalez argue that Congress intended a similar approach for Section 1255. Although the Chevron deference doctrine frequently figures in immigration litigation, both parties in Sanchez v. Mayorkas argue that the controlling statutes unambiguously compel the opposing conclusion they reach. In November 2020, the Board of Immigration Appeals pronounced Section 1254 AF4 ambiguous in an unrelated case. If the Supreme Court sees ambiguity in the statutes, the government argues the court should defer to the consistent DHS practice of denying adjustment of status to TPS holders who entered without inspection. Sanchez and Gonzalez contend that the agency practice does not warrant Chevron deference because it developed via a series of informal, non-precedential decisions generally involving litigants without legal representation and lacking briefing from stakeholders that could furnish a basis for full-fledged agency consideration. Parsing the opaque and intricately cross-referenced statutory provisions will have momentous consequences. More than 400,000 individuals have TPS. Half of them have lived in the United States for 2 decades. Although the majority are not eligible for a green card because they lack a family member or employer sponsor, thousands may meet the eligibility requirements, and most of them entered without authorization. If they cannot adjust their status in the U.S., they will, as a practical matter, be forced to forego lawful permanent residency and continue to live in temporary status that is renewable every 18 months but can disappear if the government terminates TPS designation for their homeland. For many, leaving the country carries too significant a risk of years-long absence or worse. Okay, I'm run out of time here, but I wanted to get that whole thing in because it's actually really interesting. If you didn't get it all live on the radio, check us out on UPTV or YouTube. This will be up at some point soon. And then you can, read this more carefully. This is from SCOTUS blog. It's a Supreme Court blog about various cases before the court. And I think it's kind of interesting and important. Anyway, I've got to run now. Thank you for watching. This has been CU Immigration. We'll see you again next time. Bye.